Free speech, ironically, too often comes at a steep price these days. Where is the line between legitimate human rights complaints and frivolous claims of hate speech, which sometimes simply means that one person's viewpoint has hurt someone else's feelings? Well, joining us from Calgary today to discuss this is Neilson, Vice President and Director of Communications at the Justice Centre for Constitutional Freedoms. Good to have you with us, Luke.
Thanks for having me, Paul.
You bet. Now, the team at JCCF recently came out with a new report entitled Speech on Trial, Censorship by Human Rights Commissions. Can you give us a bit of background as to what human rights tribunals were originally designed for?
It's a great question. My understanding is that human rights commissions and tribunals were designed to solve a problem of too many cases reaching the traditional court system. Judges often and court systems often don't have the capacity to handle every discrimination complaint. And moreover, judges sometimes lack technical expertise in the narrow area of discrimination and human rights law. So my understanding is that human rights statutes were created in the 60s and 70s to empower commissions and tribunals to deal in an expert way and deal efficiently and quickly and affordably with discrimination complaints between citizens and employers, between citizens and landlords, etc. As you can tell from having read the report, our belief is that human rights tribunals have wandered. They've lost their way, and they've now become far more aggressive to the detriment of Canadians' rights and freedoms.
Yeah, it seems like the majority of human rights cases these days isn't so much on employment. Well, we're not going to hire you because you're, this color skin or whatever it might be, right? But rather they're dealing with allegations of hate speech or discriminatory behavior, right?
Mm-hmm.
Yeah.
Yeah, absolutely. As the report states, the problem of aggressive human rights commissions and tribunals, where aggressive refers to prosecuting ordinary, sincere, comedic expression of Canadians, really arises from the law. On the one hand, you have fairly narrow human rights legislation, such as the Canadian Human Rights Act at the federal level. That legislation narrowly prohibits discriminatory publications and signs within the areas of employment, housing, accommodations, the provision of goods and services, etc. It doesn't authorize the Canadian Human Rights Commission to prosecute what you might post on a Facebook page or what you might say at a public council meeting. On the opposite side of the spectrum, you have provinces like British Columbia, Alberta, and Saskatchewan with legislation that empowers commissions to prosecute discriminatory or allegedly discriminatory expression, not just within those narrow areas, but also anywhere that expression might occur, whether it's in a newsletter or on your website or on a Facebook post. And, at the end of the day, citizens in Alberta, British Columbia, Saskatchewan, anywhere where there's overbroad human rights legislation, those citizens are just hoping that those commissions exercise restraint, that those commissions care as much about freedom of expression as ordinary Canadians do. And as you can tell from the report, that's simply not the case today.
Well, again, it seems that somebody's had their feelings hurt, they're feeling offended, they feel that somebody's expressing hatred toward them. Now, again, is that even criminal? I mean, is it a criminal offense? I mean, most of the time we're not seeing any kind of jail time. We're seeing fines being issued, right?
Mm-hmm. Absolutely. I was just discussing this with our legal team, and the Criminal Code, Section 319, sets a very, very high standard for prosecutions of quote-unquote hate speech. Section 319 prohibits the public incitement of hatred and the willful promotion of hatred. And the Supreme Court has understood the term hatred to refer to a very extreme emotion of vilification or detestation. Hatred does not count as an emotion or an intention to humiliate or to degrade or to offend. It sets a very high standard. The problem is, while the criminal code and the traditional court system sets a very high standard for hate speech prosecutions, this human rights legislation in provinces like BC, Alberta, and Saskatchewan set a much lower standard. You'll notice that the language is not about the willful or intentional promotion of hatred. It's about allegedly discriminatory publications or signs that are likely to expose someone to hatred. So again, we're not talking about any person's intention to infect society with hatred language. We're talking about language that may happen to expose somebody to feelings of hatred on a tribunal's definition of what that means.
The problem with that, fundamentally, I think, is it's so subjective. It's not objective, right? I mean, it's a bit like handing out speeding tickets to drivers when the speed limit signs are unclear. So how would anyone know when a line has been crossed? Okay, I know I'm speeding now. Now I know I'm being hateful. I'm vilifying somebody. Yeah, really? So it's just it puts, I guess, the alleged offender in a very precarious position here. And problem is here too, and very frustrating, I think, for many Canadians, is that someone can face very lengthy and costly proceedings for expressing a controversial or a dissenting view. And apparently the complainant gets the costs covered by the government, but the defendant is stuck, footing their own legal bill.
That's my understanding of the situation as well. So if someone levels a complaint, unless they solicit or engage with external counsel, their legal bills will be covered. Whereas the defendant is in the unfortunate and precarious position of having to pay for their own legal defense. And believe me, these prosecutions are not efficient or fast in the way that I'm sure the framers of the original statutes that authorize commissions and tribunals imagined. I mean, these prosecutions can take months or years to defend against. And so really there's asymmetrical outcomes. Complainants can walk away without having spent a dime. Defendants experience great financial difficulties, often damage to their reputation. And to your point about arbitrariness and not knowing how fast to drive when there are no speed limits posted, this is exactly the situation Canadians are in. When you have language that prohibits expression that is likely to expose someone to hatred, it's not clear to ordinary Canadians like you or I where that line is. And when the rules are vague, all behavior becomes reckless, and inactivity is the only rational outcome. If I tell you, Paul, don't do wrong today, but you don't have an established definition of wrongdoing, for you to do anything during the course of that day is reckless, and the most rational course of action for you is to do nothing, which is exactly what we see in Canada today. We see increasing self-consciousness, we see increasing self-censorship, because Canadians are afraid that earnestly and sincerely and passionately engaging with their school board about what kinds of materials their 6-year-old children are exposed to can lead to costly, humiliating, and it's really unfortunate. So,
oh man, it stifles free speech big time. And again, I mean, so something needs to change here. I think even practically speaking, although some people it may not hinder because they do have the means to pay for their own legal costs, but I think it would certainly reduce the huge number of human rights complaints that we're seeing on these, and I think many of them frivolous, if they had to pay for their own costs and kind of level out the playing field there. I mean, well, can you share an example of what kinds of cases we're dealing with? I mean, maybe touch on the BC school trustee Barry Neufeld. He's got a crazy situation there. Again, his concern was the SOGI. He was criticizing certain aspects of the sexual orientation and gender identity policies we're seeing in BC schools there.
Yeah, absolutely. The report identifies many concerning cases of tribunals weaponizing the statutes in the system to punish ordinary Canadians. The case of Barry Neufeld is extraordinary. There's a long-time and trusted school board trustee who's engaging earnestly with his school board about the direction of education in his school district. I mean, what exactly are trustees supposed to do except raise concerns about how students in their districts are being educated? And of course, the BC Tribunal ordered him to pay an astounding $750,000 in costs to the plaintiffs. And so if that doesn't chill expression in Canada, I don't know what will. I'm not convinced that all tribunal or commission cases are frivolous. Like, at the end of the day, we don't like discrimination. We don't want people to be discriminated against in the areas of employment, housing, or provision of services. But for a tribunal to be authorized by the law to order or to punish somebody to that extreme extent really is a shot across the bow to every Canadian who cares about freedom of expression. That's why it's generated the press it has. And I'm glad it has, because Canadians care about their tradition of freedom.
Yeah, freedom matters. It does. I mean, now in this case, a guy like Barry Neufeld doesn't have the financial means to pay that. I think I think he's appealing it, if I understand correctly. But we'll see what happens with that. But it's the process, though, that he's gone through, the incredible stress on a person having to go through that for years, essentially, and again, funding your own, legal defense in that as well. I mean, who wants to, take the risk of speaking out on some of these controversial issues if the other side can just put you through the ringer at government expense, taxpayer expense. So the other concern I have with this here as well, and this is, I think, a serious thing. My understanding is that hate speech prosecutions, the defendant cannot raise the defense of truth. The truth should matter, shouldn't it? Nor the defense of lack of intent to harm. So this person wasn't intentionally trying to harm somebody. You can't actually use that as a defense, which, again, my understanding is that you can use this if you're in a criminal hate speech trial. Then you could. But apparently in these human rights trials, you can't.
Absolutely. I mean, at the end of the day, nothing prevents a defendant from expressing to a tribunal, look, I had no intention to discriminate. I had no intention to be hateful. But at the end of the day, you have to look at the language of the statute. In British Columbia, and I understand Alberta and Saskatchewan, the language doesn't care about the defendant's intentions. The language cares about the effects of the expression. And so if I was a defendant in a tribunal case, I could say all day, look, I had no intention to harm. I had no intention to expose someone to hatred or contempt. And the tribunal can reasonably say, look, the language isn't about your intentions. The language is about the effects of your speech. And the problem is, who can control the effects of speech? Who can control whether or not somebody is offended? It's too low a standard, and trusted leaders like Barry Neufeld get caught in the crossfire.
The report that you issued here calls for the repeal of these censorship provisions in the provincial human rights legislation that empower human rights bodies to investigate and penalize lawful expression. But realistically, what would it take to get provinces to actually do that?
Well, we live in a democracy, right? Our government is accountable to the people, right? We don't live in a dictatorship. We don't accept arbitrary interference in the free society. There's nothing preventing every Canadian watching this show today from contacting their premier, from contacting their Minister of Justice, forwarding them our report, and saying, look, this legislation gets it wrong. Like, at the end of the day, Paul, we're going to encounter uncomfortable expression in our lives. We're going to hear religious beliefs we disagree with. We're going to hear views on history and politics that we find outrageous, that where we question the motives. Are these people really seeking truth? Do these people, are they merely trying to provoke and offend? Sometimes we're going to encounter uncomfortable expression in society anywhere on the political spectrum. Now, one solution to that is to say, well, let's just surrender to the government broad and unlimited authority to punish whatever they want to punish. That's intolerable, because in that society, there is no freedom. And when there are no rules, people become self-conscious and they self-censor because the cost of earnest engagement is far too high. So
how seriously are we going to take this, right? So we do have, the ball's in our court in one sense. If you want freedom, the squeaky wheel gets the grease, perhaps, so we need to speak up. Hey, thanks so much for your time today, Luke. I'm just running out of time here, but I appreciate what you folks are doing there.
Thanks so much for the conversation, Paul. I appreciate it.
You bet. Luke Neilson is the Vice President and Director of Communications at the Justice Center for Constitutional Freedoms.